Ladies and gentlemen, we continue with our third section, the section on the principle of non-discrimination. And as I said before, the structure would be such that we have Mike to introduce the issue with the principles, and then we have two commentators. One will be Kati Betzlin, and the other one will be with us online, because unfortunately Richard Piotrowicz lost his flight, yeah, or missed his flight, yeah, and but he's with us online. So let me just say a few words on this panel. Mike's comment for this for this special panel was, or is, how can we balance the need for privacy with the need for data about discrimination? The problem is that we have learned not to trust Big Brother to guarantee the confidentiality of personal data. I think this is really something we have to discuss, because on the one hand, you know, there's the need to collect data. On the other hand, the question, how far do we go and what do we do with this data? Whatever we pretend, but many people have also a bad experience. Oh, sorry, I just wanted to say one more thing. We have now with us Shams Asadi. She's Human Rights Counselor of Vienna, and she, with her office, is one of our partners. And thank you very much. She helped, you know, with two colleagues in the organization of this meeting. So thank you very much for this. Okay, I come back to Mike. You have the floor for the introduction.
Thank you very much, Helga, and welcome back to all of you. I told you this morning I dislike the term vulnerability, but it's very important to understand, I think, who is trafficked and also who does the trafficking. Now, only 3 of the 25 principles that I waved at you this morning focus specifically on this topic of measures to prevent individuals or groups who are reckoned to be especially vulnerable to being trafficked. The latest information I saw is in a new version of the National Referral Mechanisms Handbook, published earlier this year by the Warsaw-based Office for Democratic Institutions and Human Rights, part of the OSCE. It lists a series of what they call pre-trafficking vulnerabilities that it says have been found to increase the likelihood that particular people will be trafficked. It comments, for example, on the vulnerability caused by an individual's personal experiences, such as family violence, caused perhaps by alcoholism or other problems. It also identifies what it calls the vulnerability of entire communities that have particular features, such as Roma and Roma-related groups in some parts of Europe. And it talks about the marginalization and discrimination that occurs within some communities that makes particular individuals vulnerable to being trafficked. Well, at least this is rather more focused than where we started off in the year 2000, where there seemed to be a sense that all women or all children were vulnerable. Now, as I commented at the beginning, there are inherent contradictions between focusing prevention efforts on particular categories of people on the one hand, which would be based on data collected about people who've already been trafficked, and then on the other hand, the need to discourage the authorities from collecting and keeping lots of personal data about such people. In the document distributed today, there are 3 principles on this topic. I'm going to just read out one of them. It says, measures to prevent human trafficking should pay particular attention to preventing particular social groups or categories of people from being trafficked where there is evidence that such groups have been trafficked in disproportionately larger numbers than others. That's to say, are particularly vulnerable to being trafficked. But I also want to emphasize that there are other principles linked to this, particularly principles concerning the importance of basing prevention on accurate information. Now, that principle that I read out was based largely on a judgment from the Inter-American Court of Human Rights concerning Brazil, situations that Gabriela and I are familiar with. In the European context, I've been worried about the way that anti-trafficking measures target Roma and Roma-related minority groups such as Roma, Sinti, Ashkali, and Egyptian in the Western Balkans. And of course, the discrimination there is an issue that goes far beyond the issue of prevention of trafficking. It concerns discrimination in general. And it concerns discrimination not only against people who might be trafficked in the context of prevention, but also discrimination against people who have been trafficked, and potentially discrimination against traffickers or against criminals, and the ease of convicting people from certain minorities compared to others. My worries can be reduced, if not eliminated altogether, if I'm convinced that the data, the research and data being collected is being collected, stored, analyzed with utter objectivity and great care by professional and objective researchers, rather than by state officials who may already be biased against particular nationalities or minorities. The problem is that once data is handed over by objective researchers to political entities or even branches of the security forces, but I confess I'm thinking particularly of the Home Office, the Ministry of Interior in my own country. Once data is handed over to them, there's a great danger that it's misused. Now, I don't want you to misunderstand what I'm saying. 14 years ago, I helped publish a volume about collateral damage caused by trafficking. And 14 years later, I have to say, I think that was not collateral damage. I think it was deliberate damage. And in this context, my worry also is not that there is a likelihood or a possibility that data will be misused. There is a certainty in some countries that it will be misused. We've seen all sorts of crude categorizations used in the context of talking about who is trafficked. Women from Nigeria, for example, without distinguishing between more than 100 different ethnic groups, and the fact that even the women who come from one particular state or province are very varied, and their situations are quite diverse. I once saw an international organization's report that commented that young women who are ambitious are at a particular risk of being trafficked. This was in Romania. As if anti-traffickers should favor keeping women and girls at home and in their traditional place. I was absolutely horrified. Now, because inaccuracies and distortions and inaccurate stereotypes have crept into so much public information about patterns of trafficking, the principles we've drafted refer not only to the importance of avoiding discrimination, but also to 4 principles that emphasize that prevention should be based on accurate information. And today I'm going to go a bit beyond those principles and say that an obvious operational implication of these principles is that in those countries where there is a national rapporteur on trafficking, that rapporteur, among his or her responsibilities, ought to be checking and commenting on whether information made publicly available about trafficking victims in his or her country is accurate or has been based on good quality research and objective analysis. For it's high time that the nonsense and the propaganda and the racist stereotypes were weeded out. Thank you very much.
Thank you, Mike. Thank you, Mike. Yeah, please go ahead. Yeah,
Absolutely.
I would now like to invite the two commentators to comment on that. First, I would like to ask Rizat Piotrovich. He is professor in Aberystwyth University, Department of Law and Criminology. He is a former member of Greta, was even vice president there. He has been visiting professor in many universities, almost over the world, if I may say so, but in many countries. He is a consultant for Council of Europe, for IOM, OSCE, UNHCR, the ICMPD, the EU, etc., etc. And last but not least, he is member of the board of editors of the International Journal of Refugee Law. And when we prepared this meeting, I asked also him to provide a quote. And his quote is that he thinks that the conflation of human trafficking and smuggling by politicians and by the mass media victimizes trafficked people all over again, because they are not recognized as people who have been subjected to severe exploitation. So we are keen on hearing more about that. The overall issue is on prevention, and please, you have the floor.
Thank you very much, Helga. Thank you for the invitation to take part, and I apologize to everybody that I'm not in the room. It's only the second time in my life I've missed a flight, but and I hope there won't be a third. So thank you for your patience. The quote which Helga mentioned was one that I gave kind of out of context, because I wasn't really thinking about the topic about which I would be invited to speak, but I think nevertheless it is valid. In some countries I've even met public officials, sometimes NGOs, who are not aware of the difference between smuggling and trafficking of human beings, and that clearly affects their ability to do their job properly. So I think the quote is valid. Now, I would like to also to thank Mike Dottridge, who kindly shared some of his thoughts on this issue with me a couple of days in advance, so I had a bit of time to think about it, and I really do appreciate that. Mike has emphasised the need for accurate information, especially towards the end of his introduction this afternoon, including the avoidance of stereotypes and also to reduce or to avoid discrimination. And I entirely agree with him. And I was going to, however, try to widen the discussion by mentioning one of the principles that Mike has drafted, except he already quoted it himself a few minutes ago, principle number 11, which is about the principle that measures to prevent human trafficking should pay particular attention to preventing particular groups or categories from being trafficked, and so on. Now, that to me is important because for me, as I read it, it means that we, of course, should understand that not all discrimination is necessarily bad or is necessarily illegal. And this principle number 11, for me, actually advocates a kind of positive discrimination in certain situations. And I do not see anything wrong with that. Now, of course, I understand fully that the term discrimination in these principles is used in the sense of illegal or negative discrimination against particular groups on whatever basis. And I do not dispute that in any way. But I would like us to remember that there is such a thing as positive discrimination, and it needs to be sometimes used legitimately in the context of dealing with particular groups of people, sorry, Mike, who are vulnerable. But I tried not to use that word. But now, the next thing I want to say, and I had a discussion about a year ago with Berbel Oul about this, and Berbel, of course, has been very heavily involved in issues to do with data protection with regards to trafficked people. And the point I wanted to make, though, and I will say that Berbel and I disagreed to some extent on this, is that states need, or governments or government agencies or ministries, they need some information to give effect to their obligations. And not every, I believe, not every government agency or ministry is necessarily acting in bad faith, although I would accept that in many countries the Ministry of the Interior or its equivalent is very, very suspicious, to put it mildly, of the kind of people that we advocate providing more help and support for. And I've seen this on country monitoring visits with Greta, and I will not name any particular countries, but I've been all over the continent making these visits. And so I want to make a few comments on the issue of collection and use of personal data. And of course, one of the things that one needs to appreciate is that in the European context, within different countries, possibly within even different government agencies, the understanding of confidentiality and the protection of personal data can vary enormously, really. And sometimes the way of using personal data is done very wrongly, but not even in bad faith, but out of ignorance. And I'll give you one example, which related to the identification of trafficked people. In one country that I was monitoring, we were visiting a state-run shelter, and it was obviously a state-run shelter. You could still smell the fresh paint. And the issue was that they told us they had 7 people currently living in the shelter. Now, we never asked to meet trafficked people. If they asked to meet us, we would agree, but we never asked to meet them. And without consulting us, they brought these 7 people out to meet us, almost like they were in a zoo. And 6 of them had apparently been trafficked for labour exploitation and 1 for sexual exploitation. And we were taken completely by surprise by this. We did not expect it. We would have refused had we been asked if we wished to meet those people in those conditions. Now, this was data, a violation of personal data of the most egregious kind, because these people were actually compelled to stand there in front of us. And I honestly believe that people running that shelter did not think they were doing anything wrong. So if you don't understand your obligations, it's very hard to give effect to them. Now, just a few more points. I'm conscious of time. I do think that data has to be shared sometimes for legitimate reasons. And to give you one example from the Council of Europe Convention, it's the obligation, I think if I remember rightly, Article 16, the obligation of states to ensure safe repatriation of people who have been trafficked to another country. You don't just, in other words, put them on a bus or a plane and hope for the best. Now, and this is where Berbel and I disagreed. I don't see how you can safely return a trafficked person to the country from which she or he has been trafficked in a safe way unless you make some sort of preparations for their arrival in that country, whether it's through relevant NGOs or IOM. And to some extent, obviously, you have to pass on basic information about that person, the most basic, of course, being her or his identity, I guess. And of course, the people receiving that information should and legally must be conscious of the need to protect that and to limit access to that information. But again, we come to the issue that in some countries, some agencies simply do not appreciate the extent of their obligation, or how, even if they understand the obligation, they do not understand how they should properly give effect to it in order to ensure protection for the people whom they are there to provide protection for. Now, one of the other issues, and I'm slightly broadening my mandate here, is that in order to carry out these tasks effectively, money is needed. Of course, resources are needed. And one of the big problems for me is that in many of the countries that I have visited, they're running or they're trying to run effective programs, but the money for those comes from Brussels or the USA or Norway grants. And I would rather they use foreign money than not run these programs at all. But for me, these are short-term funding arrangements which indirectly have an impact on their ability to effectively protect trafficked people, including their personal data, and to avoid discrimination. So those are the most the main points I wish to make. What I would say to finish off, to conclude, is that I do think there remains a significant need to raise awareness in some countries, maybe in most countries, of the need to use and protect data appropriately. And that does not mean denying everybody access to all data. It cannot mean that. But there's also a need, I think, to change attitudes among some of those who do have access to the personal data of trafficked people. And that includes the prevention and avoidance of unlawful discrimination. Thank you for your attention.
I think we're going to discuss this further because we will have the panel afterwards. I would just, because you mentioned Berbelul twice, I mean, unfortunately she can't be here, but we had her with us, and on data, and data, yeah, it is a sensitive issue, really, you know, and of course there is interest in data, and the interest varies very much, you know, because I mean, I remember when we, you know, for instance, the police or the Ministry of the Interior normally don't want to share their data with others, you know, or vice versa, you know, they don't want, because the thing is the interpretation of the data, you know, what they do with it. So it's not only the privacy, but the whole thing, you know, how they interpret data. And with this, they fuel or excuse their policies, you know, the politic in general. So this is certainly something we would have to look at more closely, and I regret also personally not having you here, because it would be for us maybe a bit easier, you know, also to exchange that, but it won't be the last time that we talk about what do we do with data and what problems come with this. So I would just continue with the second commentator, with Katrin Betzlin. She is lawyer and criminologist, and she is a professor for criminology at the Faculty of Law of the University of Vienna. Her main research topics are gender studies in criminal law and criminology, focusing on domestic violence, labor exploitation, and trafficking human beings, and empirical research on legal practice of criminal prosecution of human trafficking and social fraud in the construction industry, and many more. I won't mention all that. You can follow this. You have the bios also at our website. So please, you have the floor for your comment.
Thank you, Helga, for the invitation. And I will start with a point that was addressed just now, because I had not the time to make notices to it, concerning the data of the police and that they are often not willing to share the data. This is a problem in Austria too. Whereas we have a provision in the criminal proceeding law that universities and other scientific organizations have to right to see the data of courts. There is no comparable provision concerning the data of the police. This is not such a problem if you only look at the practice concerning criminal prosecution, because in these cases we see every case in the court files afterwards, but we will not be able to see in which cases the police doesn't see a case of exploitation or human trafficking, where we as a scientists would see one. Yeah, this is a problem. Yeah, maybe I will continue this point. I do not see the great problem in the misuse of the data that scientists deliver. I rather see it the other way around, because the practice of the police delivers the bias we see in the files. The cases that are not recognized by the police as exploitative cases or as human trafficking cases, we will never see in the files. So we as scientists cannot study them. The only possibility would be either to go to cases at the labor court, but I'm not sure if there are many cases. In fact, we would have to do field studies, really to go into the agriculture, into the construction industry or something like that, and therefore we have not enough scientists in Austria, at least. Maybe in the English-spoken countries, they have more criminologists, I think. In Austria, we have only 2 institutes and not with very many people working there. I think we have 4 persons at the moment in Vienna and 2, I think, in Salzburg and 2 in Linz. This means 8 persons that have to cover all fields of criminology, and as far as I know, I'm the only one dealing with human trafficking at the moment. Yes, and I can't do field studies. Maybe it would be a cooperation with MENMIA if they get the 10th number of personnel, which would be necessary, in fact, I think, because if they could make field studies, they would have 10 times more cases. I'm quite sure that this would be the result, but yes, there is no money for this purpose. There's only money to address smuggling. It's still like it was shown in a criminal in a film some years before. There are still only 6 persons at the Bundeskriminalamt, our authority dealing from the Interior, Ministry of Interior, dealing with human trafficking. 6 persons that are dedicated to human trafficking, and I think 30 or something like that dealing with smuggling. This is a great problem. Yes, do we really need data? I don't think we need more data concerning the risks of both victims and perpetrators. I think we know already that they often come from the same problematic background. They do not have a good vocational training. They do not have an income, no social security at the country of origin. And the only difference between them usually is that the perpetrators have another character and they are not hindered by any moral deliberations to exploit people coming from the same, often from the same village, but from a similar background of great social problems. I think the criminology has shown the causes of becoming offender for decades, if not 1.5 centuries, and this is the same in human trafficking. Therefore, the only thing that is interesting is to know more details about the modus operandi, the methods of recruiting, the methods of where the people are exploited, in which areas of economy. This would be important to see where we have to recruit, where we have to recognize more victims, but there we are again at the point that we need field studies, because the files in court and even the fields at the police too, they are already biased. They look especially at the groups like Roma or something like that, although there hasn't been an Austrian study specialized on that as far as I know, because they have recognized themselves some children, I say, that were brought to Austria partly to sell roses, not in for a fair price, then to commit pickpocketing, and sometimes then the third step is to being exploited in the sex industry, and therefore they look at these groups where they have already seen cases. And in other aspects, like the construction area, where we haven't had so many cases till now, although we had some, but with rather few successful criminal proceedings. This is the problem. They usually look at the same cases they have already had. And yes, there would be it would be necessary to have more training for the so-called experts that often are not really experts because they are not aware of the broad picture that we have in the exploitation and human trafficking. And the first start is if we look at the cases that are dropped immediately. And here I'm at the point that there is a great discrimination between victims that meet the expectations of the police, how a victim should look like and what it should do and what it should not do, and on the other hand, victims that do not meet these expectations. And if a victim has committed some crime and maybe it only has used some a false document or has made a false has given false evidence at the first interview by the police because it was afraid to report the offender to the police. In these cases, there is a great risk that the case is dropped immediately, even if Lefe ÜBF is supporting the victim. Sometimes even a lawyer has already been named to the court, and still the case is dropped for lack of evidence because it's not that the victim is not trustful anymore. Another problem is if there is no violence in cases of sexual exploitation, then they do not look at the problem if there could be a labor exploitation in these cases. I've seen about 150 cases till now because I'm just looking at files at the court in Vienna. And I had some cases where it was rather clear that there has been an exploitation in the form of labor exploitation because the whole money has been taken away. But at the moment when the victim says that there has not been any violence and that in fact it consented to do this job after seeing that it has no other possibilities in Austria, in the moment the case is dropped, usually, at least at most of the cases, and they do not look at the point what were the working conditions like, what was the payment like, yes, and so they will hardly ever see labor exploitation in the sex industry. Yeah, and therefore the circle is closing now. Therefore, these victims that are not typical victims as many expect them, they remain invisible, and so the outcome both of the work of the police and the scientific work that has to hold on these cases, they remain biased as long as we do not have more information from the field. Thank you.
Where we have the panel, and we will discuss also concrete situations with it. But what we see is, of course, that data is important. You know, it is important, and it is important what we do with it. You know, and what data we collect, yeah? and how we interpret it afterwards. Because I remember a time, you know, when we had human trafficking high at the agenda, when there were people saying, "Oh, well, it's not worthwhile, you know, to invest much funds in that, you know, because there are not enough, you know, victims, for instance, or for other purposes, you know, we would then suddenly feel, oh, you know, we would use the data to make sure, or to pretend, let's say, that this is a huge problem, yeah? And so this has not, from my perspective at least, this has not changed very much, and also how institutions and organizations share data, you know, how transparent the things are, or most of the time they are not, you know, because we don't really know, you know, for instance, also European institutions, you know, the Europol, others, you know, or Eurojust or whatever, you know, how they get their data and what data it is, you know. So all this is certainly important and needs to be discussed. Maybe not, we cannot do everything. It's also for other institutions, you know, to do that. But what we realize is that certainly also in the future, this will be an issue we have to look at and to see what we do with data. So thank you for the moment. I would like to ask the panelists to come to take a seat up here. And I would like to ask the commentators, you know, just to remain available, you know, because we could then further discuss it also with them or get comments from them. So please, Vasilis Karasiotis. He's the lawyer who brought the so-called Chowdhury case to the Human Rights Court in Court of Human Rights at the EU level, European Council of Europe level, and was successful. I would like to ask Evelyn Probst. She's the coordinator of LEFE. This is the Intervention Center for Trafficked Women in Austria. I would like to ask Markus Zingale to come to the up here. He works with the Men Via. He's a sociologist and works with Men Via, the support for male victims of trafficking and exploitation. I would like to ask Pierre Cazenave to come up here. He's an anti-trafficking specialist, now working with ICMPD, but he has worked for many years with the Terre des Hommes, yeah? And I would like, oh, he's here. I just thought we have one chair missing. No, Jean-Pierre Gauci. He is senior fellow at the British Institute of International and Comparative Law. And of course, we also ask them to provide a quote so that we get an idea of what would be the focus of their contribution. Let me start with Jean-Pierre Gauci. He said, discrimination is intimately tied with experiences of trafficking and the barriers faced by trafficked persons, responses to trafficking, and how governments and others understand and respond to trafficking realities. Understanding and addressing the links between these issues is key. Yeah, we agree so far, but we will see what else you can add to this quote. Then Pierre Cazenave said, many anti-trafficking initiatives have done more harm than good. Actually, we know that, but you can also tell about concrete experiences you made, included when their intended beneficiaries were children. This is particularly true when the anti-trafficking agenda is used to stop vulnerable populations to move across borders. Yeah? Then Markus Zingale, as I said, Men Via, the support for male victims of trafficking. He said victim support should aim at counteracting the stereotypes that often form the basis for discrimination. Data about affiliations of affected people can be shared to put a negative spin on a discriminated group, or otherwise can be used for anti-discrimination measures. So this is interesting. We will see how this can be done. Evelyn Probst, she said human trafficking is possible because the non-discrimination principle cannot be converted in a discriminatory framework. Let's see what you mean by that afterwards. And last but not least, we have Vasilis Kerasiotis here. He said, we are entering in a new era of post-COVID competition between EU member states for migrant workforce. So we will see if this is the case and what is the case. I would nevertheless like to start with Evelyn, yeah? Please.
I hope so much that you don't put me as the first. What do I mean with that? I would like to start with a case, what we had recently at court, and this might be one of these court cases. Katharina might look at it because it ended up in court, and it didn't end with conviction. It ended with acquittal. This case started somehow 10 years ago. 3 women sexually exploited in Austria. 2 of them, all the 3 of them deported to their country of origin. Then they were like in a situation of vulnerability in their country, which is an European country. It's like a country in the continent of Europe, outside of the European Union, but not too far away from here. And it happened that one of these women, then years and years after the situation of exploitation, went for search for support with an NGO in this country and she already identified herself as a trafficked person. Therefore, she went to this NGO. And it came out that via this NGO, we got involved into the case. This all happened then in 2019. So shortly before the pandemic. We, together with the NGO, we found out that there was a court case in Austria. We, as a victims' rights organization, have never been informed about this case. Also, there is a kind of an obligation by the police to pass to us all the data, so it didn't happen. We found out that the court case was already closed, but we could reopen the court case because there was new evidence. So we went to the prosecutor and informed the prosecutor about that there is new evidence and that the prosecutor could reopen the case. Prosecutor reopened the case, and my colleague did like a force of, I don't know, half a year to make it possible that all these 3 former victims of trafficking are able to come back to Austria to testify at the court. There was like restrictions because they were victims of deportation, so they had a re-entry ban, and one of them was already living in a different country, so there was no reason to go from this European country back to Austria. But so we managed that it was possible that the 3 of them were coming back to the court. Also, there would have been a slight possibility that we implement some measures like video transportation for interviews, but this was not implemented. Finally, then, the first woman was interviewed at court, and before the interview started, the judge in the court procedure argued 15 minutes why she didn't know that she should have known that she is not allowed to work in Austria because she has no proper documents for that. Therefore, she should have known that she will end up in a situation which harms her. End of that story was then that the perpetrator was acquitted because there was no sufficient evidence, because the victim herself was like blamed because she was without papers in Austria. This is for me the story to enter if we are in this system in a discriminatory framework which is pushed with all legal measures, but as well the discourse about certain legal measures. We hardly can implement anti-discriminatory measures in the practical life. Kirill today said we have to talk about contextual prevention. We are using already very often the frame of contextual vulnerabilities. But as long as these vulnerabilities are still perceived in the overall structural division of perception of individuals, the vulnerabilities were not perceived in the person, in the situation, in the framework where the person is put in. We tried to, and I also follow up with what Christina said, are we really able to see that trafficking, that we can end trafficking? I still want to believe in that. But actually in our practical field, we are only focusing on preventing more harm. And this preventing more harm enters in that the trafficking situation already happened. And then we can prevent more harm only if all these trafficked persons, trafficked women, get access to their rights. But accessing their rights, they have to be perceived as rights holders and not perceived as that ones who are intruding in a certain kind of a system, into the state system as a migrant, into the system because this is a social system and it doesn't belong to them, etc., etc. One of our main arguments of this contextual vulnerability is now in a draft law, what we will present on access to residence permits. Since years, we have part of the Council of Europe Convention and other papers, the statement that a resident has to be on personal grounds as well. It cannot only be linked to the criminal procedure, because then we see that, what Katharina said before, that a biased system where an undocumented migrant per se is somebody who already acted against the state and therefore cannot be taken seriously in a criminal procedure, this system decides about access to residence permits or not. So we're on the level of discrimination because the bias then decides who gets access to rights. So we argue we have to work on it on an individual level, also to contextualize that we don't have to count if there is such a number of victims from this country or such a number of victims from that country or in that area. So I strictly oppose, in the sense of data collection, that these data are neutral data, where we then have neutral measures which can be implemented. Nobody ever did an effort, and really effective effort, to collect data on access to residence permits in the European Union. There is a little bit of a report here and there, but this is not fully, nobody ever went fully after it. And out of these actions of residence permits, we could really find out something about the target group who has been trafficked. Nobody ever did really effort in collecting data on compensation. We did it, part of a project together with La Strada International. We did it in Austria. We went into 124 court files and tried to find out what was the reason for accessing to compensation. But was it worthful to then implement a better policy on that? No. Because it was not the data which was interested by, because we want to have data that fit into a policy review, where then the measures can be prevention of migration in this field, but not prevention of trafficking. So maybe I would agree with Christina that maybe it's not, we cannot end human trafficking because there's so many different frames we have to combat with. So this running after the idea that there is good measures to be implemented who are not discriminatory before we have to challenge all these other frameworks. And lastly, as Susanne said before, when we were debating about now we need a new directive on human trafficking, because this directive is already old. It's a kind of a framework. Why is this an argument that something is old? What is the content on that? But we argued that if we if we really need a revision of a very old document, and we have arguments why it's old, and it's the 2004 directive on access to residence permits. Because if you look in this paper, still the definition of trafficking is not there. Still the concept of trafficking is not there, because it is still perceived as in this directive that the victim is not a victim, it's a kind of co-perpetrator. Because the residence permit only links up, and there's only right to this residence permit if the victim is not in contact with the perpetrator anymore. What is this? What kind of concept do we have here? So this is really old. It's from 2004. It's before we had the joint definition on trafficking. And if we still agree on that we have one definition on trafficking, what we try to implement on, then we have to revise papers which are older due to that, not because they're old, because they have a different definition. And I said this before today, if we still agree on that we want to have a joint definition on trafficking, then we have to focus on that and not like put our force into this demand debate, which again builds up a discriminatory framework. Thank you.
Thank you. Markus, do you have similar experience in your field of work?
Hello? Yes. First of all, I have to add information about my quote, which I sent you on a really hot summer day. And at least the last point, I formulated it not very well. The data which I want to be shared are not data about information about the person or social personal data about attributes to which belong minority or group the victims belong. But I think I thought on the information about their the way they came in the exploitative situation, so a qualitative information about their experience and about what they find. Also in this sense that Mike Doddridge pointed out in this principle, I think it's number 13, so the view of the survivors on what would be necessary for preventive programs. So that's data that's relevant, and I come back to you, Katrina Petzlin, that we could make a qualitative research on the experiences of male victims. Regarding this issue or another. So it's I think it's relevant to collect data, but data in the sense of relevant information that comes from the survivors themselves or from us as professionals who work with them. So therefore I'm really thankful to be here, because my brain has a lot of new input received today. And what can I add is also a case and experiences, a case of a group of Romanese, Roma people that we supported last year. And therefore, for today, I did a 3 clicks research on internet and found an article about the rise and history of discrimination of Roma people in Bulgaria. And one small information that I would want to share is that in the years ahead, just ahead of the system change, of the breakdown of the communism in Bulgaria, the authorities, together with a civil movement, they have done a campaign against the so-called Turkish and Albanian and minorities, and the Roma minority was not even named, but they, all of them had to change their names into Slavic names, into Bulgarian names, and this was just ahead of the breakdown of the industry and of the dismantling of the social welfare system there. And so it's no wonder that in the 90s, the Roma population and also the other minorities lost the jobs without finding new ones. Some of them lost their apartments, and they had to settle again in slum-like ghettos. We have seen, if you remember, we've seen also the pictures from districts in Bulgaria in the 90s, if I remember right. So that's the situation where men came to a southern region in Austria and began to work, recruited by a subcontractor in a construction site, and they worked for 3 months without getting the wages or just a small part of it, really small part of it, and there were false information, other unfair means, threats with the time, and when they contacted the trade union and they were handed over to us, we together with us, they were able to report to the police. Everything worked really fine, and a lot of institutions made a good job, especially also the Chamber of Labor. They gave them the legal assistance at the labor court, which was important because the criminal court case was not closed, but the accused was acquitted for the charge of human trafficking. At least he was accused because he had stolen part of the wages, and which where there was hard evidence on it. And in front of the labor court, now I come to a small detail which is relevant. Every worker, she or he, has the same right to sue the fraudulent enterprise and to try to receive the missing wages back. But the code of how is it called? Code of procedure at the labor court foresees that for every single worker, own lawsuit has to be filed. And the judges are independently defining the date of the trial. The bus costs from Bulgaria to Vienna and then to the southern region of Austria would have been more than €100 one direction. Manvia would have covered part of this, but in the for the reason of these costs, part of the costs, and for organizatory reasons, all of the men could not come to the trial. So it's the obstacles were too big to personally participate, and at least the lawyer of the Chamber of Labor was able in the end to reach some agreements with this fraudulent enterprise, and they received a small back pay of the not 6,000 but 1,500 and so on. So for the employer, he got lightly off, and he had some inconveniences. So what do I want to say? The affiliation of these people to the Roma community regarding this obstacle of really having access to their rights and to claim for the missing wages is not relevant at all. I would think so. That the circumstance that the fact that they are poor and could not afford these bus tickets on their own and not with our partly help is a question of poverty. And on the other side, this example shows that a formal, equal and free access to rights does not mean that this is effectively given for migrant workers. And those men, as all of our clients, if they belong to a special group or not, all of them are part of the migrant workers here in Austria, or migrant workers in the widest sense of the term. And for this group, the legal practice lags behind the reality of the European labor market. And there has a lot to be closed of gaps before we can go further and I don't know. Yeah. Now I should find the point in the end, because I think the data that about the information about practical obstacles should be collected, because I think in the European countries they might be the same. The effective access to the rights to claim for missing wages or for the violence that at the criminal court as well as in front of the labor court. This is a problem that's not. We cannot find a solution if we talk about minority affiliation. So.
I would like to jump to Vasilis, also to your former case you had, on the Chaudhry case. Did you have, no, don't touch it, it works. Did you have similar experience on that? What Markus said? Please, go ahead. And you have some ideas on how to, let's say, how to change, I think it's a bit utopic, but nevertheless, just let us know.
Not really. First of all, thanks for the invitation. I have to admit that while trying to follow up on the implementation of Chaudhry judgment, me and my colleague from UK, we have made a submission to the Committee of Ministers asking just one thing, having in mind that all the victims of labor exploitation and human trafficking for the purpose of labor exploitation had left the place of exploitation, but at the same time being replaced by others under the same conditions, I was feeling desperate myself, because if we want to address human trafficking, we need to try to see the bigger picture and try to frame a solution, maybe. So I was totally convinced that the European Pact and from 2008 and the Greek legislation implementing the Pact that prohibits any regularization schemes were the main cause, and the lack of reform on immigration rules was the main cause of this labor exploitation that takes place in the Greek farming industry. At the same time, we have the same phenomena all over Europe, in south of Italy, in Spain, in Portugal, almost everywhere. And for me and my colleagues, the only way is to try to reform immigration rules, because sometimes the negligence to act on this direction creates or facilitates forced labor and creates discrimination in the field. So we made a submission just for this purpose, that the only measure that Greece should take in order to comply with the Chondouri judgment is the immigration, the amendment of immigration rules, and in order to try to create a legal scheme. On the other hand, while handling another case, I was also totally convinced that if we apply the rules, the positive rules of Employer Sanctions Directive to all those people who are working under exploitative working conditions, that means that we should initiate a huge amount of criminal proceedings. And even if we had the best public prosecutor who want to proceed with criminal proceedings, what will happen will have derivative migration status for the former undocumented migrants in case the public prosecutor characterizes them as victims of labor exploitation. They will gain residence permit, at least according to the Greek law. They should leave the place of exploitation because if they don't do so, this is a reason to withdraw the residence permit. And this will create a huge pull factor, in my opinion, for other undocumented migrants to come. So the enforcement measures of criminal and the means of criminal legislation is not, in my opinion, the appropriate measure to combat labor exploitation in the field. On the other hand, of course, in some cases we need to initiate criminal proceedings or even cases in European court when there is state negligence to act in line with the positive obligation for prevention, identification and punishment. But the most important in order to change this vicious cycle or the narrative is to create a legal scheme, sectorial one, in the sectors where we face lots of problematic situations that are against the European rules. Because if they don't have the threshold of human trafficking, most of them, there is a labor force of thousands of people, undocumented migrant workers in Greece at least, but I'm sure that in other European countries that are suffering under these conditions. And my quote was related to the fact that out of necessity, in fact, and especially during COVID times, we have seen something unique. People who were working under these conditions in Greece for many years have, the 40% of them have decided to leave the country to go further in Italy or Portugal because during COVID these countries initiate measures for migration, for better migration policies. And this has attracted a migrant workforce, and at the same time, my country, Greece, has remained without working hands. And we can discuss further what kind of responses Greece has done in order to overcome these missing working hands.
Yeah, thank you. I guess this will certainly be interesting for discussion. Let me come to Pierre. You have had experience, it's several years ago, but nevertheless, you had experience working with Terre des Hommes about children, Roma children, and others, you know, they were whatever, you know. So tell us a bit, what was it? Were they discriminated? What happened with them? You know, it was quite interesting when I read about that. But to hear from you what it was will also be interesting for all of us. Please.
Okay, thank you very much and good afternoon, everybody. My name is Pierre. I work for the International Center for Migration Policy Development. Yet, as Helga just explained, I have some long-time collaboration with Mike over there in the room, and work that I have done in relation to Roma communities, Roma children, and their families. And as such, I'd prefer to start with the principles, and the principles that were outlined by Mike in his publication and that relate to measures in read Principle 2 that aim at preventing and combating THP, and these measures should not violate the prohibition on discrimination. Yet, I think that we are discussing about something that goes beyond the measures that aim at preventing and combating trafficking in human beings, other measures within the legal systems of our countries that have a detrimental effect on the situation and vulnerability of already vulnerable populations that lead them that exacerbate their vulnerabilities to trafficking in human beings. And as such, we have several discriminations, several structural frameworks that discriminate or that have the potential to create conditions where which will exacerbate the vulnerabilities of already vulnerable persons. So Mike counted three principles that relate to discrimination. I had counted 6 that were relating to that, but perhaps my math is not so good. It never was my cup of tea. But from 2, 5, 10, 14, 11, and 19, I think are very relevant. And even if we saw discrimination clearly outlined in these principles, I have not found in the document anything related to social inclusion, and we're talking about Roma communities when you asked me to come to social inclusion or to exclusion. There is one reference made to exclusion, but not to social exclusion as such, and I think that it is important for this paper to refer to these 2 concepts also of social inclusion and exclusion when we talk about discrimination, of course. So when it comes to the structural elements that contribute to discrimination, and that exacerbate the vulnerabilities of already vulnerable population to trafficking, I think we should start with those that are outside of the anti-trafficking field. And here we have the immigration-related rule, the asylum. We have in Europe the common European asylum system. We have a number of rules that may, to a certain extent, contribute to putting people in vulnerable situations. If we look, for example, at and there is a lot of dichotomies all over. The dichotomy refugee and beneficiary of subsidiary protection. If you're a refugee in some countries, you get access to the labor market. If you're a beneficiary of subsidiary protection in some countries, you don't get access to the labor market. If you're a beneficiary of international protection on the basis of humanitarian grounds, you don't get access to the labor market. And that creates vulnerabilities, even though those persons are, fleeing situations that should prevent them from returning home. They are not able to have perspectives and therefore may have be obliged to have recourse to a black market which exposes them to risks. Then there is a second situation, and this is the one I worked on a long time ago, where we had, protective, we could find protective norms that would address the situation of third country national children, unaccompanied minors, unaccompanied and separated children arriving to our countries. They were arriving in Europe in very vulnerable situations, and they could find a structural, a legal, a normative framework that was, conducive to offering protection avenues in some countries to those unaccompanied and separated children. But if you were an EU citizen, and especially coming from an ethnic minority that is being discriminated against in the country of origin, and you move to another country, then you would not have access to these protective mechanisms that the common European asylum system has obliged all the EU countries to offer. So you would be an EU citizen, children of ethnic minority moving across borders. You wouldn't get access to the protection offered to unaccompanied and separated children for third country national. And you wouldn't get access, because the systems were not prepared to cater to your needs, to the national child protection system and the measures that are there to protect children. So you're not treated on the same basis either of a national children or of a foreign children, but that is third country national, and for which the systems is equipped to cater to the needs of whom the system is equipped. And then you have measures at the structural level again that, that are, in my view, likely to lead to discrimination. These concern, for example, victims of trafficking, the dichotomy, victims of trafficking coming from a third country and victims of trafficking coming from an EU country. We look at their, the issue of reflection period and the issue of residence permit. This is largely influenced by whether you are allowed to reside in a country. And if you are, and as Diane Schmidt said in the morning, 50% of the victims in the European Union come from the European Union, and therefore are entitled to reside and stay to a certain extent, with the 90 days rules, etc. But in general, it creates a whole different story if you come from a third country and how your case is being dealt with, especially by immigration services when it comes to the issue of reflection period and residence permit. So this is what I wanted to say for the structural level. And at a more operational level, I think we also have discrimination that is latent in a number of countries because of situations and social situation of social exclusions that have lasted for decades already, and that affect particularly the Roma, Ashkali, Egyptian, Sinti communities and other Roma-related groups in Europe. And you have this difference of discrimination that occurs when it comes to authority recognizing that a community is more engaged in a specific form of trafficking. Let's take forced marriage. The authorities do not have much problem in many countries to acknowledge that there is a lot of trafficking for the purpose of forced marriage when it comes to the Roma community. That they don't have much problem to say. However, they have much more problem to say that there is to recognize and afford the status of victim to children who are begging in the street and coming from Roma communities, because it is, according to some practitioners, something that is, cultural or associated to. So this is a problem. There are practitioners that still need to receive a lot of, or to get an improved understanding of what the reality of some communities are, and how is it that they should deal with that. So this is what I wanted to say about the discrimination at structural and more operational level. And if I am allowed, I would just like to have a little say about data, because a lot has been said about data, and especially disaggregation of data according to ethnic groups. And we have two schools, yeah? The school where you disaggregate the data on the basis of ethnic minority. And many countries adopt this approach. And other countries say, no, we don't want to collect data and disaggregate it per ethnic minority, because it will lead to, a lot of problems linked to, that will contribute and further fuel this public narrative that is very toxic at the moment, that will say a lot of migrants are actually engaged in this and that. And I think, it is important to get the right data, as was said by many speakers before. And I think that ethnic disaggregation of data has a lot of advantages in order to prove, in order to give facts, in order to say that there is a lot of engagement, for example. But it's not because we have to be a bit wary of these data solutionist approaches, where everything is solutions with data. If we have the data, we know we get it right. But then if we look at movement across the world, such as the racial profiling or the disproportionate targeting of the black communities when it comes to policing, the number of deaths in some countries that are caused by the police to black communities as opposed to white communities. It is very well documented. We have all the data we want on that. Yet nothing changes. They are still targeted, and they are still disproportionately affected by the phenomenon. So data solutionist approaches are fine. It's good to have data, but we must first and foremost make sure that the data is used for the reason that it is collected for. So let's not collect data if we don't want to use it. I mean, this is what I wanted to say. And finally, when it comes to the issue of data disaggregation, you have For example, the European Roma Rights Center, it is an organization that works well, and has published in 2012, I contributed to this report. I don't know if it was 2012, I feel old now. No, it was some time ago, let's say, that they published a report called Breaking the Silence. And this report was supposed to, by a Roma organization and a representative Roma organization, to put the finger on a topic that was not touched upon and that remained something, which is the overrepresentation of Roma in some forms of trafficking across Europe. And they did it, and they had been advocating at that time, and I think they still do, for data disaggregation, because they have been able to prove that they are disproportionately represented in the number of victims, and that traffickers were disproportionately represented in the number of traffickers. Yet they were also able to unveil a number of useful elements that proved that there was structural issues that were at the bottom and that were underlying and that caused this overrepresentation, and that this was not necessarily things that were related to cultural issues or whatever. So I think with this, I covered my point, and I wish you a very good day. I am keen to listen to Jean-Pierre.
Yeah, just wait a moment. Maybe we come back. Yeah, again. So I will now give the floor to Jean-Pierre. I think it's quite good because you can. You said discrimination is tied to experience, yeah, and how governments and other states react. So tell us a bit. Listening to the others, you know, at a panel, just tell us a bit about that.
Yeah, I think. A lot of what I had thought of saying has been touched upon, but well, here we go. We'll try not to repeat too much. I wanted to start from basically the summary of the EU MIDAS, the Fundamental Rights Agency Minorities Survey, and the key finding of that was basically that racial, religious, and ethnic minorities in Europe are over-policed but under-protected. And I think everything we've heard today reflects that. That discrimination in anti-trafficking often results in minorities not being protected from trafficking, in basically discriminatory responses to trafficking that excludes them from protection, but at the same time, basically ethnic minorities being overrepresented in people being prosecuted, either trafficked people being prosecuted for other crimes, etc., or traffickers from ethnic minorities, or ethnic minorities being overly represented in people prosecuted for trafficking. So, and I think that's something that's important to highlight, that basically discrimination affects both the kind of protection side, but also the prosecution side. But starting from the prevention side, because I mean, that was one of the things that we were focusing on here today, I think it's important to also go one step back. So it's not only about anti-discrimination anti-trafficking efforts being non-discriminatory, but it's also about the impact of discrimination before someone is trafficked or is even in a situation of trafficking, and how discrimination results in people's vulnerability to trafficking. And that's discrimination in access to goods and services, whether it's access to education, access to healthcare, etc., but access to employment, access to decent employment conditions, etc. And I think that is something that we need to kind of reach back into if we want to understand kind of vulnerabilities and discrimination as causing those vulnerabilities. That discrimination, obviously in the European Union, the equality framework has a kind of very limited number of categories that we tend to think about, and I think that is one of the problems with the international and particularly the EU anti-discrimination framework, which is that it talks about gender, race, ethnicity, religion, age, disability, but it doesn't talk about status discrimination. It doesn't talk about nationality discrimination, and actually very often excludes nationality discrimination and excludes status-based discrimination from the anti-discrimination protections that those legal frameworks are supposed to protect. The other thing I wanted to mention is basically the idea of discriminatory policies in the name of anti-trafficking, and I think this has been raised multiple times today, but basically because very often trafficking is looked at through an immigration lens, or rather an immigration control lens, we see the kind of use and abuse of trafficking as a justification for restrictive and discriminatory immigration policies, border practices, etc. The other thing that I think is something that, I mean, we've talked about research, we've talked about data, is around kind of EDI, so equality, diversity considerations in service provision more generally in the anti-trafficking space. To what extent are people from different groups see themselves reflected in the people providing the services, but also in the people designing the policies, designing the programs that are being designed supposedly as a response to trafficking. And I think this goes back to the point raised earlier about very often minorities are there to be rescued rather than consulted. And I think that was a really, really important point to mention. The other thing I wanted to talk about was data. Again, in the use of and misuse of data, I have absolutely no I have no question that data is misused, but I think also the excuses for not collecting data or not disaggregating data is also often misused, and very often we use the excuse of we don't want to stereotype certain groups, etc., not to collect data that's going to make us make systems look bad, whilst at the same time we have absolutely no problem collecting and publicizing data that makes those minorities look bad. And I think that is where you really start to see what the real priority and the real objective behind some of those excuses for not collecting and not publishing data start to come across quite clearly. The other thing is, obviously, we can't talk about data as if it's some sort of objective thing. And every piece of data, every piece of analysis will always have kind of the biases, will always be underpinned by the biases of who is collecting it, who is compiling it, who is analyzing it, who is producing it, what is being produced for, et cetera, et cetera. The other thing, sorry, I'm trying to kind of skip through my notes to make sure I try not to repeat too much, is that very often one of the things that we found as well in our research, for example, on determinants of anti-trafficking efforts, is that a lot of the systems are themselves essentially racist, essentially anti-migrant, right? And that creates both a problem with the system itself, the processes themselves, but also prevents those processes and those systems from being used for the stated purpose for which they were created, but rather they end up being used as kind of an extension of a migration control agenda and a border control agenda. The last thing I wanted to mention is the need to bridge the gap between the anti-trafficking movement and the anti-discrimination movement. And I think there's some movement in that direction, especially kind of my main experiences in the kind of anti-racism movement, but there's some movement in bringing the anti-trafficking and the anti-racist movements together, but very little of that. And I think we need to do a lot more of that, partly because very often the anti-trafficking movement doesn't have the anti-discrimination capacity, and the anti-discrimination movement doesn't have the anti-trafficking capacity. And there's a lot of learning that can be done from one movement to the other, but also working together, there can be, I think, opportunities for progress that can come from those movements coming together. And then obviously we need to think about, again, my key focus tends to be kind of racial minorities and migrants, but also thinking about other groups that are excluded from protection and or whose needs are not understood. So thinking of persons with disability, thinking of persons with intellectual disabilities, for example, et cetera, but I'll stop there and have more time for discussion.
Yeah, thank you very much for the moment. I would like, before we move on, we can also, of course, it's also open for question, comments, etc. But I would nevertheless like to go back to Rizat Piotrovic, to Mike, and to Katie, just to, maybe you would, I would imagine you have to comment on what you heard, and maybe this is also something which yeah, let us continue thinking in this field of non-discrimination. Richard, would you like
Yes.
to?
Please, thank you. Just briefly, and the point I wanted to make relates to something that Jean-Pierre was saying towards the end of his intervention, and this is the issue of getting reliable data and hard information that you can rely on. And this has been a perennial problem for Greta, trying to get reliable statistics from different governments about the number of trafficked people, the breakdown according to gender or sex, types of exploitation, and so on. And it's like trying to compare apples with tractors. The differences are so great sometimes. And many countries, and I'm not I can't remember which particular countries now, just don't give reliable information, or they'll talk about cases of trafficking. And by a case, do they mean one human being, or do they mean a prosecution or an arrest in which maybe 10 or 20 people were arrested, or 30 or 40 victims were identified? So it has been extremely difficult to gather reliant, comprehensive information which would give us a real picture about what is actually going on in a particular country. And I'll finish there. Thank you.
Oh, please come up here, because then we can see you. Just go ahead.
First of all, I have to apologize. I restricted my statement to criminology, but of course we have other scientists too, especially Marta, who is here. I'm so sorry. I think you're from the sociology? Yes. And she's just doing a study, and I think she has even done something like a field study before concerning sex work to look at what forms of exploitations may be there, isn't it? Please excuse that I forgot it before. And then, of course, we have the political science, and we have Helmut Sachs. Oh, I think here it is. We are even planning a study together from the January. But I also have to add something important to the proposal before of Mike Doddridge concerning the national rapporteur that should decide whether study should go public or not. I cannot support this because I have bad experience with national institutions concerning studies. I've done a really great study with 4 scientists concerning stalking, and it was Pinacek who was my contact person at the Ministry of Justice, and he always forgets to answer whether we are allowed to make our study public. And this and similar experiences may be the cause that now university members are not allowed to do any studies anymore if they do not have the right to decide on their own whether it will be public or not. Therefore, it wouldn't be able in Austria to do universities wouldn't be able to do studies anymore that go public if a rapporteur has to decide about it. Yes, this was very important, I think.
Maybe this is special, yeah, for Austria. Okay, Mike, please.
So you'd love me to talk about censorship. Let me start. First, I'll go to Pierre and say thank you for mentioning the word social inclusion. We're, in the Anglo-Saxon world, we have some strange ideas, and social exclusion and inclusion haven't been so much part of the vocabulary as discrimination. I think you're absolutely right. We should be explicit. And some of the points in these draft principles about this issue of discrimination, non-discrimination, I think we can reformulate them a bit. Let me just talk a bit about data. I think we're talking about all the information published on trafficking, we're talking about somewhere between 20 and 90% being propaganda that should be put in the bin. The very fact that even in Europe, we take seriously a report published each year by the American Department of State on the issue of trafficking is quite extraordinary. American academics cite it as if it's a dependable source. Well, I remember a marvelous dependable source even before the TIP report, the ongoing US State Department reports on human rights, spent the 1980s telling the public that there was no problem in the African state of Chad, where I was documenting mass disappearances, torture taking place 50 meters from a USAID office. And then suddenly, when there was a change in government, they could change from night to day. They could change completely. So politicized information is a huge problem. Cathy, you needn't worry. I'm not in favor of censorship. I wasn't suggesting that national rapporteurs should have any right to stop publication. But there is a need for someone to point at information that is racist or discriminatory or inaccurate or badly analyzed or badly done. Greta hasn't done much on that. I don't want to make Greta into censors either. But I think national rapporteurs could comment on information that is undependable or seems to make very big claims, but actually to be rather dodgy. Now, I know in my own country that is a problem. We had a national rapporteur, more or less, called an independent anti-slavery commissioner, who focused a lot on car washing facilities, which I saw as a fairly xenophobic, possibly racist measure to pick on Albanians and various other groups who were working in hand washing cars. Sorry, I should have specified car facilities. So maybe the national rapporteurs aren't the objective, independent people I would like to see, in which case we need some more, maybe institutions from civil society. But there is a need for us, first of all, to recognize quite how inaccurate information has been, and to really start explicitly distinguishing between evidence-based information and ideological assertions, whether they are good or bad. Thank you very much, Helga.
Thank you very much. Yeah, please, questions, comments, answers before we close this panel? Please, you have the floor. Oh, come out here, yeah, so that they can see you. Yeah, it's not only the microphone, but with the live stream, otherwise they can't see you. Go here.
Thank you very much. I have two questions. One is, because initially we also discussed about data protection online, and now I would like to put the context of the EU policy, and currently there is a proposal of the EU regulation on child sexual abuse. And the question is to Helmut, to Pierre, but maybe also to Daya, because this regulation aims to reveal child sexual exploitation online, which can be also a result of human trafficking. Currently, the proposal is actually putting the responsibility on the online companies to be responsible for the content, the online content, which means that as a result, the companies will decrypt the content and will access the private communication whenever there is a risk that there is a child sexual abuse online. And I just would like to hear from you, like experts on child rights, whether you see it proportional measure, because it means that the private communication of all of us will be at risk. And of course, since like I work for a European Sex Workers' Rights Alliance, and since we do a lot about digital rights, we believe that also the privacy of many sex workers will be absolutely at risk, because we are like, just giving the power to companies to decrypt our private communication. So this is my first question. Second question is regarding what happened during COVID, because we know that actually everything stuck. But what I also could see, there was like huge dynamics of how the labor market changed, and there was a huge rise of the gig economy. And I hardly hear what were the effects of this gig economy, of this kind of like platform workers, platform jobs, like what's the result? Because we know that in many European countries, many undocumented migrants actually do work for these delivery services where the artificial intelligence is just giving them the tasks, and where we know that there is a massive exploitation of people in this gig economy. However, where for instance, I read the report of Council of Europe about online trafficking, I haven't seen any single mention about it. Whereas I see that this kind of huge thing is happening, and we are openly speaking about exploitation within the gig economy, but it's not probably as serious as trafficking. So we didn't speak yet about trafficking, just about very severe exploitation. So my question is maybe for Markus, whether you have the possibility to deal with these gig economy workers who are predominantly migrants working in precarious conditions. They have very little chance to unionize because there is an involvement of the AI. So my question is whether you have any indications on what's going on there. Thank you.
Thank you. Susanne? Just a moment, maybe we take one or two others and then.
Thank you. Yeah, because Irena started to talk about EU law, and I think in the first panel we were also discussing, like, is it needed that we have more legislation, or is it rather the implementation? But because he talked about EU law, I was also thinking, you mentioned the sanctions directive, employee sanctions directive, you mentioned the EU resident permit directive. So I was just wondering, do you also have any recommendations to the revisions of EU law at the moment? Would that make a change? And if so, what should be changed regarding to the sanctions directive and the residence permit and maybe other EU law? And I'm also saying this because we know that not only the EU trafficking directive is to be revised, but also the victim rights directive. And we heard, we don't know, we didn't get it confirmed, but that maybe also the employee sanctions directive will be revised, and also the EU residence permit will be revised. I heard it yesterday, so I was just wondering what kind of recommendations you would have.
Mm-hmm. Thank you very much. Yeah, there were a few questions. Pierre, Markus, Rizat, yeah? Or maybe I take you for, yeah, okay. Okay.
Well, with regard,
go ahead.
The brief point I wanted to make about possible revisions of EU law is a general rather than a specific one, which is be careful what you wish for. The moment you open something for revision, you might end up with something worse from the perspective of trafficked people or victims of crime than what is currently in place. This is why there was a lot of opposition to reviewing the Refugees Convention in 2001 on its 50th year. So for me, the issue would be less about identifying particularly weak parts of the relevant EU law, but more about trying to have more effective, good faith implementation of the existing law.
Mm-hmm. Okay. Pierre, maybe? Pierre? Markus?
Hello, does it work? Yeah. So I think I got a question which was related to the online sexual exploitation of children. And so I'm not familiar and necessarily competent to comment on this subject. However, there is one thing that I believe is that trying to access material and child pornography, or having exchanges that relate to the sexual abuse and commercial sexual exploitation of children and materials of children online should be monitored. It is a crime. So whether that concerns adults is another story, but when it concerns children, it's a crime. And as such, I think it should be monitored, not necessarily by companies who should be given the right to intrude into a home, but I think companies have a duty to make sure that also they, there is no crime that are being, or at least there is a sort of due diligence that should be in place. But as I said, I'm not so competent to comment on the subject, but I do believe that crime should be fought, yeah.
Markus?
Yes, question was if we have a contact to men who are exploited in the gig economy. Yesterday I was assisting two men at the court, a criminal court, who were exploited as parcel delivery drivers, and in the weekend they did the newspaper delivering. And the accused man was acquitted, so he was not punished for the charge that was on human trafficking, and no other charge was I don't know, immediately in the trial. He would have been probably sentenced for others if the judge would have seen the exploitation by unfair means, and one unfair mean of this job giver was that he promised to organize marriages for residents, but he did not any step towards this, and it was just at least from the point of view of the criminal police and our view, it was a false promise. It was an unfair mean for the exploitation, but the judge did see this proof in other direction. And for their claims, they should now go to the labor court. So it's our first case. It was our first case with drivers, and I don't know if we will get in contact with the food delivery workers in near future. I don't know. They already formed a trade union or a small organization under them, and this would be the best prevention if the workers in this field, but also in all other fields of precarious work and independent, if it's independent work or formally independent or dependent work, doesn't matter. The rights of the workers should be strengthened so that the sanctions directive in this point would be implemented right in all European countries. This regulation of the European labor market towards high standards of workers' rights would prevent what you mentioned as migration pull factor or so, and would prevent crimes and severe exploitation too. That's my point.
Evelyn?
European Sanctions Directive, this is a nice link to data collection. I don't know if you know, I've heard it, but then there was never any more information about that the European Migration Network is collecting data on the implementation of the European Sanctions Directive on behalf of the Commission. So there is, and I was quite surprised because there's something in place, and I was also surprised that nobody was informed about that. And then we tried to meet up with the respective authorities who are connected with that on the level of the ministry, and said first yes, and then never went back to us. Because again, it looks like that there's no interest, that there's then a critical review on these data which are collected, or an impact how we could collect data around the implementation of the European Sanctions Directive. And there's two small comments on my panelists and the debates. I think I would like to raise it again, and I raised it a couple of times here in this round table. For me as an NGO, which we perceive ourselves also as activists for the rights of the people we're supporting, we don't like to be perceived as service providers. But I think this is actually the shift what already happened. It was said in the morning that there was like a shift from shrinking the space of NGOs, where the part of the work is to, via services, get access to rights for trafficked persons, to international organizations who are offering services, full stop. So, and this is some of the shifts which also goes with this, how can we include meaningful, as Irena said, experts as part of the debate, as expert sex workers and experts 24 hours caretakers. There's lots of groups who are specifically vulnerable and know about what is going on, if even we as NGOs are having this shrinking space. Maybe we could link up better in a sense of a movement, and I like it very much what you said, that we should link up with other movements. And I'm a little bit doubting that we in the anti-trafficking field are a movement. But maybe if we take that as such, that there are this like punctual linkages to be able to go into depth and to open a space again for critical activism towards accessing more rights would be very important. And my last word, yes, I am opting, and I think we did it as we were on the way there for a change of the residence permit directive, but this is the arguments I already had before. And I know that very often, agreeing with Richard, we never know if we get something better than before. But I think this directive is so bad that there can't be any worse afterwards. But we have to accompany that with a campaign on that. It doesn't help if any directive is only changed. We have to campaign for it, why, for what, and what means the implementation.
Mm-hmm. Okay, there are two other comments, please. And then I give you the floor, too.
Thank you, Helga.
Come here, that we can.
Yes, Ludovica Banfi from the Fundamental Rights Agency. Thanks also for citing our data. No, just one thing, because we published recently on the implementation of the Employer Sanctions Directive. So we published a report in June of 2021, looking how the protective elements of the directive were implemented. And then the Commission published its implementation report, also citing that. So just for you to know, but maybe you know. And well, interestingly, of course, it's an instrument. I agree with Richard, who mentioned that I'm not sure that opening these directives at this moment would bring a better situation for the right holders, for the migrants. That said, it's incredible to say that it's still one of the directives that is most protective for the migrants themselves. It's the directive that criminalizes severe forms of labor exploitation. So at least the member states have to criminalize that, because otherwise it's only trafficking that is criminalized. And as we know, it's a threshold that is difficult to meet. Many of us said that. It's difficult to prove trafficking. It's difficult to prove the intention of trafficking. In many cases, we see it also in the Commission reports. You start with a number of suspected cases. Half of them are investigated. Half of those investigated are then get, or even less, a conviction. So overall, having criminalizing severe forms of labor exploitation is a way to go, but it shouldn't only happen for the regular migrants, as it's currently the case under EU law. The other thing I wanted to say on the residence permits, it doesn't look much better anyway, even if there is a provisional residence permit, also for the victim of severe forms of labor exploitation. The data we have is that 1/3 of the member states used it, and as Vasily said, it's only a reaction, it's a derivative status, but I think can agree that labor migration, having labor migration schemes would help. And there I was wondering whether in the first session on prevention, it was interesting for me to hear that there is somehow a view of prevention as not really working, as something whereas in our cases, or somehow with maybe the details of examples were not discussed of what worked or how they were thought through, and maybe so more time is needed to discuss exactly what worked or what didn't work, in fact. But I hope that the approach to prevention is not dropped somehow, or that message doesn't come out, because I think it's key. I mean, what we also see from our reports is that in the case of labor exploitation, informing workers of their rights, informing them of the complaint mechanism, monitoring and enforcement through labor inspectors and other monitoring bodies, standard setting in the context of business are all preventive mechanisms, and so I hope we can take the discussion on that forward as well. And last but not least, just something maybe positive, some of the protective elements of the Employer Sanctions Directive now, if you look at other instruments of EU law, like they've now recently proposed a revised single permit directive, and there are some of these protection. So this is the directive that obliges member states to issue the residence and the work permit together. They now include some protective provision, for example, permit in case of unemployment for 3 months, something similar. Of course, maybe it would not survive to the discussion in the policy cycle, but still, yeah, some. In the context of that directive, it wasn't. In the case of unemployment, it wasn't there. So the possibility to foresee, in case of unemployment, that the permit is not lost immediately, basically. So in the context, yeah, we can discuss.
Yeah. Okay, thank you very much. You said our report it's a fundamental rights agency. I don't know if you said that, yeah? So, Helmut.
Thank you. Just 2 comments. One on the question in relation to this review of the other directive on child sexual abuse and exploitation. And then I would have one final comment on monitoring. On the first one, well, I definitely agree with you that one has to be very careful what will be the outcome of this whole review process when it comes to this question of how to protect privacy, while at the same time balance interests of those children who, like if they have been exploited, if there are abusive images online, when you have also an obligation then to act quite quickly and swiftly, at least on the basis of some interim measures. And my understanding so far is like these detection orders, they should serve that kind of purpose. But on the other hand, clearly, of course, you have to respect principles of proportionality and the principle of privacy as such. It cannot be a backdoor to get access to all kinds of confidential information just by claiming this is to protect children from abuse or things like that. So, of course, like almost everything in the human rights field, it's a question of balancing. And then it's also a question on what kind of structural mechanisms will be implemented to safeguard like principles of judicial review if some interim measures are taken. On the other hand, I think this whole area of social media, as we can see, discussions about Twitter and censorship and self-censorship, etc. I think that's a whole area which needs very thorough further discussion in general. What are the obligations of the service providers, so to say, like social media services, and what are the state responsibilities, etc. So I think that's really one of the key areas for the future as such. On the monitoring, perhaps just to mention, because national rapporteurs have been mentioned, I was Thinking of, like Mike, if you have had opportunity already to discuss with Bärbel, like in Germany, they are currently working on a kind of a model national rapporteur mechanism. I'm currently not sure what the current status is. I think it should be completed quite soon. So over 2 years or so, they developed what would be the essential requirements for a national rapporteur on trafficking, while at the same time also on sexual exploitation. And it would be interesting, I guess, to see what would be her response, her feedback on the guiding principles. Because as I said in the morning, I think one essential element of this whole prevention discussion also needs to be how to operationalize monitoring of prevention effectively, so that it becomes not just a buzzword. Everyone speaks of prevention is better than the cure. I think there is potential clearly to make this also a policy area which can have substantial indicators, for example, but which also needs some infrastructure for implementing it. And from my perspective, national rapporteurs or similar mechanisms should definitely be such institutions. Thank you.
Yeah, thank you very much. Just to maybe a last remark, if you want, Jean-Pierre, and then Vasilis, or let's have Vasilis first. And you.
No, I don't have much to say. I think on the question of EU law, I think I agree with Richard on kind of be careful what you wish for. But I also agree with Evelyn that the residence permit directive in particular is really, really problematic. So I think if I had to change or revise one aspect of EU law, I think it would be that one in particular, specifically removing the conditionality of protection, but also more broadly.
Mm-hmm. And Vasilis?
Thank you. Responding to Suzanne's remark, I would like to draw your attention to the fact that the European Pact from 2008 and the set of all these directives we have discussed till now, I think they have failed to address the labor mobility inside the European Union. And all these policies have created an invisible number of thousands of undocumented migrant workers all over European Union. And suddenly, COVID arrived, and we have seen a change of policy from some European countries, and I think this is the right direction. Despite the fact that there are positive elements in Employer Sanctions Directive or in the recast Single Permit Directive, the main logic remains the same. Those who are there is this dichotomy between legal status and irregular status, and those who even they are entitled to receive their wages according to Employer Sanctions Directive, they should immediately leave European Union, unless there are severe forms of labor exploitation. But I wanted to come back to what I said before, because even if we have, in Greece at least, we have the residence permit for exploitative working conditions on humanitarian basis, but these people, when they receive the permit, there is a big controversy here. They leave the place of their exploitation because otherwise they will risk this permit to be withdrawn. So they leave Manolada or other areas and they go to Mykonos to work, but at the same time they are being replaced by others under the same condition. So the only way is to abolish the main logic of the pact and try to think beyond and create labor mobility schemes through maybe recast of the single permit directive, and or create sectoral labor schemes in areas where every member state has missing, working hands. I remember that there used to be a legal migration directive that has been abolished, but this should be main policy of every member state in order to create a more sustainable migration opportunity. Last but not least, the legal migration schemes should take into consideration the fact that the undocumented migration is the main cause of the vulnerability and of a situation that could amount to labor trafficking, etc. The only way to combat labor trafficking and exploitation is obviously to give more opportunities for legal migration.
Yeah, maybe in next year we will hear how it works, you know, what you initiate. So, well, we have come to an end. Thank you very much to this panel, to the panelists. Thank you to you all. I mean, I think these were quite interesting, most interesting discussions, which give us food for thought for further developments. Yeah, thank you to all, and hopefully we meet again next year. I would just thank also the Chamber of Labor. We are here at the premises of the Chamber of Labor. I would like to thank the technicians, yeah, who, thank you very much. And yeah, hopefully we see next year and continue our discussion, and you continue our work where you are. Thank you.